Can I just say, what a long document title. This is probably the most important thing that Sarah Boone has ever had filed on the docket. Maybe second, because honestly, remember, she was able to get a lawyer using her circus style ad that worked. But let's take a look at order on state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome and state's motion in Lime and state's motion for examination by state expert and order on state's motion to strike defendant's admitted notice of intent to rely on the defense of battered spouse syndrome. Oh boy. This cause came before the court on September 19, 2024 on state's motion to strike. I'm not reading all of that. I'm sorry. The court having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the court file, having considered the authorities and arguments offered by counsel and for the state, and have considered the authorities and arguments offered by counsel for defense, finds the following. The matter is set for trial on October 7, 2024. See the court scheduled order and notice of hearing entered August 5, 2024. On September 6, 2024, defendant filed that certain notice of intent to rely on the defense of battered spouse syndrome, the notice. The notice provides a statement of particulars showing nature of the defense battered woman syndrome as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, George Torres. The name and address of a witness, Dr. Julie Harper. On September 6, 2024, the state filed the motion. September 13th, the defendant filed the response. September 15th, 2024, the defendant filed that certain amended notice of intent to rely on the defense of battered spouse syndrome, the amended notice. The amended notice, among other things, provides the same statement of particulars showing the nature of the defense as the notice, battered spouse syndrome, as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, George Torres. Names and addresses of 6 witnesses. September 19, 2024, the state filed the amended motion. The court finds that both the notice and the amended notice comply with Florida R Criminal P. I'm assuming that's what Florida FLA means. Medina v. State, State v. Hitchinson's, Ladd v. State, as relied on by the state, all addresses exclusion or admissibility of expert testimony on battered spouse syndrome at trial, not pretrial exclusion of expert testimony on battered spouse syndrome. Additionally, Aquino v. State, review granted, addresses the introduction of battered spouse syndrome evidence, not the pretrial exclusion of the same. The state relies heavily on Wagner v. State. In Wagner, according to the appellate's testimony, as she bent down to pick up the keys with her left hand, the gun she was holding in her right hand accidentally discharged, that she absolutely did not intentionally pull the trigger, and that she was not aiming at anything when the gun went off. The bullet discharged and struck the husband in the lower back. The trial court precluded appellate from presenting the battered spouse syndrome evidence at trial. At the hearing, no outright evidence of an accident was presented. See defendant's statements as outlined of the amended notice. Motion and amended motion are granted in part and denied in part. Motion and amended motion are granted in that defendant shall submit an examination by an expert of the state's choosing. Said examination shall take place no later than September 26, 2024. The motion and amended notice are denied, and that the notice and the amended notice shall not be stricken. State's request preclude defendant from mentioning battered spouse syndrome in her opening statement is denied. State's request to prevent any mention of battered spouse syndrome until admissible evidence of a justified use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial is denied. Oh boy. So, my understanding, maybe I'm wrong, let me know in the comments, is that they are letting her use the defense, basically. They are not going to strike it. She can use it. She can use it in her opening statement. She can go right off the beginning and use battered spouse. She doesn't have to provide evidence to the court first. And yeah, so it's going to be interesting. Because remember, if you watched my last video, the judge seemed pretty shocked that they're suddenly going with that it was a purposeful killing. That's what battered spouse means. Battered spouse means that Sarah Boone is saying that she zipped him up in that suitcase, and at some point when he was in that suitcase, she did it to kill him, to escape him, to save herself, from my understanding. That's what they have to argue. So while he was alive in the suitcase begging for help and she went upstairs to take a nap, we have to believe she was in fear of her life during the nap, and she took the nap knowing it would kill him. Unless she changes her story, right? And says something different at trial. But again, that's we've all listened. I think everyone's basically listened to her testimony at this point and seen the videos with the suitcase. I still don't know how this plays out for a jury. I don't see her ever being able to convince a jury, right? I can't imagine it. Like, if you don't know the case, because it's very obvious that her lawyer was trying to throw out that interview, and it's not going to work. But he had to try because, like, talk about the Miranda rights and stuff, because it's so damning that her saying it was an accident, it was an accident, it was an accident. And now they have to say it isn't. 4.5 years later. It feels crazy that this is, what, 2-3 weeks away, this trial. It feels crazy that we're that close. It feels crazy that we are all in a situation where we're going to finally get to see how they're going to try to play this out in front of the jury. I can't figure it out. I have to assume that they're going to reinvent the story in some way. I can't imagine they try to go with the same story she told during the interview and then say she just killed him on purpose, right? I can't imagine that that's the only change. Because if that's the only change, to me, it doesn't make sense. Oh, I'm a battered spouse. I need to escape. This man is currently locked away inside of a suitcase and he can't get out. And I didn't run. I sat there and I taunted him. I didn't run out the door. I didn't call the police. I didn't do anything. Instead, I purposefully took a nap, knowing and or hoping or planning he would die while I sleep, because a reasonable person, maybe they'll say she wasn't in her reasonable mind, right? But a reasonable person is like, what if he gets out? Like, I think that's where the sticking point's going to be, right? Where he couldn't get out. We know he couldn't get out. We know he died because he couldn't get out. But she didn't know that at the time. And I don't think the average person would risk their life. They wouldn't risk their life because, remember, she's going battered spouse, he'll kill me, whatever. I can't imagine the average person would risk their life on a zipper of a suitcase, right? Like, we know the end result. But even if you thought he couldn't get out, are you going to risk your life on a zipper and just go take a nap? Maybe they'll argue, change it to she stayed downstairs until she was sure he was dead. And then she took a nap and came up with the story. And she lied. Maybe that. But we're getting close. We're getting close where we'll get to find out.